Good afternoon, everyone. My name is Alexis Alvarez, and I'm the Director of Statewide Training at Florida Legal Services. As always, it's such a pleasure to be in community learning with you all today, and I'm very excited for the topic that we are going to discuss, which is DCF Child Protective Records for Attorneys. Now, most of you on this training, if not all, are in the legal aid world, legal aid community, and we want to say thank you for all that you do. And we want to say that we understand that sometimes when you're working with DCF records or working with a case with DCF, that it may not make sense what records are where, how do you find what records, what you're allowed to request, how do you request it, who do you call? These are all questions that I am sure any one of you that have worked in that sphere have thought of at least once in your time working with DCF. So with us today, we have Logan Bartholomew, who is the Assistant Regional Counsel for the Central Region of Florida Department of Children and Families. And Logan is going to elucidate some of these things for us. Logan is going to help us try to answer those questions that are always burning on our minds when we're working with this administrative body in an effort to give you all the opportunity to advocate best for your clients and to also, understand that relationship with DCF so that we can all be on the same page. So before I turn it over to Logan, I want to confirm, because I am getting some messages into the chat, that there is no sound. If anybody can just let me know in the chat whether or not they are receiving sound and hearing what I am saying. Okay, so I hear from someone there is sound, I can hear you. So anybody that is still having a sound issue, message me separately and I will work with trying to get you on board. So before I turn it over to Logan, I also want to say this is being recorded. A copy of the recording will be emailed to you all within 24 hours from Zoom. That email will not come from my email address. It will come from Zoom, but I am going to drop my email address into the chat. That way you can reach out to me if you don't see that in your inbox or you need anything. Other housekeeping announcement is CLE credits. This was approved for CLE credit, and I will announce that CLE code at the end of the presentation. I'll put it in the chat, I'll say it out loud, but you will also receive that CLE code with that email from Zoom in 24 hours along with the recording. As always, you can reach out to me directly, and I will give you anything that you need directly from me. So if you missed it, or you have to hop off, or you don't see it in your inbox, no worries, I'm an open door. You can always reach out to me for what you need. And the final piece of housekeeping announcements, I actually didn't ask Logan beforehand, I should have, is questions and answers. Logan, are we good with questions? Questions in the chat, questions in the Q&A?
Oh yes, ma'am. We are going to have multiple stops for questions and answers. So do please feel free to put your questions in the chat. I will get to as many as I can. I will note that I cannot answer case-specific questions. So let's keep it general, folks. No hypotheticals, nothing case-specific, please.
There you go. I'm glad we have that disclaimer. And so, with that being said, I'm going to get over the boring and stuff and housekeeping stuff and let Logan get started. I want to say thank you all in the audience for letting me know that you can hear me, one. And I will say that there is closed captioning on too if you need a little extra assistance. So feel free to show your captions. And without further ado, Logan, thank you so much for bridging that gap between the legal aid community and DCF and really getting us all on the same page so we can represent our clients effectively, ethically, zealously, and understanding the bounds and parameters of our DCF records. And so the floor is yours.
Thank you, Alexis, for that introduction. So like Alexis said, my name is Logan Bartholomew. I'm an Assistant Regional Counsel for the Florida Department of Children and Families. I'm based here in the City Beautiful, Orlando, Florida. Just by way of background, I hold a bachelor's degree in public policy from New College of Florida in Sarasota before the governor made it cool. I also am a graduate of the Florida A&M University College of Law, also right here in Orlando. I just passed my 8-year anniversary working for the Department of Children and Families. I was originally a paralegal with the Children's Legal Services unit of DCF, working on dependency matters. For about the past 5 years or so, I've been the records custodian for DCF in circuits 9 and 18. And I was upgraded to Assistant Regional Counsel once I passed the bar back in December of 2022. So although I am only recently an attorney, I have worked for a long time for DCF and anticipate that work to continue in the future. Also, just a quick legal history note. Want to give it's the 33-year anniversary of the Americans with Disabilities Act of 1990 being signed into law. Without that law, I probably would not be sitting here talking with all of you. So just a legal historical note. So let's talk about today's learning goals. Today, we're going to learn about what DCF does. We're going to learn about what records DCF creates during a child protective investigation. I'm also going to show you some examples of what those records look like. Note they will not be case-specific examples. They will be sort of, what our templates look like, so you just have an idea of what you're looking at. We're also going to talk about who can access child protective investigation records, and we'll do a demonstration on how to request those through the DCF website. No need to send in paper, no need to fax it, no need to even send a subpoena if you don't want to. We're also going to talk about one of the more commonly confused items here, what the child protective team is and how they're related to DCF and our child protective investigations. We're also going to have a little bit of information about dependency court records. So when a child is removed from the home and placed either with a relative, a non-relative, or into foster care. We're going to talk about who's entitled to obtain those records through the clerk of courts. So we've already gone over a couple of ground rules, but one of them is that all the information I'm going to be presenting to you is in general. There are some local variations that I'm not going to really be able to speak to because I work here in Orlando in the central region. So obviously I'm working in, a couple counties out of the 67 in Florida. Also, this information is subject to change. A lot of this is statute driven. The legislature regularly changes Chapter 39, which is where a lot of this law is based. So I will give you plenty of citations throughout the presentation. If for some reason, you think something might have changed or you need to double check the statute, check the case law. A note about language. So DCF uses paramour instead of boyfriend or girlfriend. So when you're looking at DCF records or when we're talking to each other, we talk about, mom's paramour, dad's paramour. I may also use the term spouse instead of wife or husband. Again, with the evolution of family law, and same-sex marriage after Obergefell. Just trying to make sure that everybody's aware that, paramour is a word that we actually use around here. And as I said before, there will be multiple breaks for questions. However, and I'm going to reiterate this before every question time, I cannot answer case-specific questions and I cannot answer hypotheticals. So just heads up on that. So now that we've laid down the ground rules and caveats, let's talk about what does DCF actually do? And we are kind of a multi-headed hydra of an agency. So obviously we do child protective investigations. That's under Chapter 39 of Florida statutes. DCF is also responsible for foster care services. So foster home licensing, post-adoption services. FYI, if you've been adopted in the state of Florida or you aged out of foster care, those folks get quite a number of extra benefits because obviously, bad things happen, but the legislature has provided. So things like Medicaid, scholarships, both in-state and otherwise. Those are things handled through DCF or through one of our contractors. DCF is responsible for the licensing of child care facilities, and that's contained in Chapter 402 of Florida statutes. That's specifically 402.26 through 402.319 of Florida statutes. DCF is also responsible for adult protective investigations. That's falling under Chapter 415 of Florida statutes. We're talking the abuse, neglect, and exploitation of vulnerable adults. So folks with significant disabilities, folks who are elderly, a lot of folks who suffer from mental health and dementia type issues. That all falls under adult protective investigations. DCF is also responsible for the economic self-sufficiency programs of the state of Florida to an extent. Specifically, we are responsible for the SNAP program, the Supplemental Nutritional Assistance Program, formerly known as food stamps. DCF also administers the TANF program, Temporary Assistance for Needy Families. DCF is responsible for receiving and processing applications for Medicaid, and we approve or deny Medicaid benefits. However, the actual operation of Medicaid benefits is handled by AHCA, the Agency for Healthcare Administration. DCF is also the single point of contact agency for refugee services in the state of Florida. We are also the single agency for homeless prevention and elimination here in Florida. DCF is also responsible for substance abuse and mental health regulation. So, for example, Baker Act facilities, we're responsible for licensing and monitoring them. DCF is also responsible for restoring criminal defendants to competency. And that also includes the Florida Civil Commitment Centers for certain sexual offenders. We are also the Domestic Violence Agency for the state of Florida. This is a good time to let you know that we have a domestic violence hotline, which is 1-800-500-1119. That's a good number to possibly give out to your clients and those who need kind of more immediate assistance. You can find out more details on all these programs at our website, which is myflfamilies, FAMILIES.com. So as you can see, DCF wears many, many hats, but today we're talking about the big one at the top. We're talking about child protective investigations. Oh, and I'm sorry, DCF is also, we also do human trafficking matters, as I believe if you go back a couple of presentations, you'll see some information there about human trafficking. So let's talk about child protective investigation records. So what does DCF hold? What information do we create and keep in our records? So DCF is required to keep all reports made to the child abuse hotline, and that's a mandatory requirement under 39.101 subsection 3 of Florida statutes. So anybody who makes a report of known or suspected abuse, abandonment, or neglect of a child, either through our phone number, through our toll-free hotline, which is 1-800-96-ABUSE. We also receive abuse hotline reports through fax. And we also receive abuse hotline reports through our website. More information, again, can be found at our website, myflfamilies.com. Just a friendly reminder, any person who knows or has reasonable cause to suspect the child is being abused, abandoned, or neglected is required to make a report to the abuse hotline, and that is 39.201 of Florida statutes. So in all child protective investigations that are accepted by the hotline, there will be an investigative summary, which will include a summary of the allegations made through the DCF abuse hotline. There will be caseworker notes, sometimes referred to as chronos. In most investigations, there will also be a present danger assessment. In some cases are streamlined by our child protective investigators, just kind of to reduce the paperwork, especially if what was reported to us is clearly not true or not supported. But in those cases where we do a full investigation, there will be a family functioning assessment done and also a risk assessment performed. As needed, child protective investigators will also create safety plans. And we also hold in our electronic file cabinets other documents from other agencies and providers. So police reports, medical records. Sometimes we have out-of-state CPS records, although we can't usually give those out as part of a records request. We sometimes even have court records in there. So for example, if there's been a domestic violence incident, the investigator will usually grab a copy of the no contact order and just make sure that's part of the case file. So some of you might be wondering, so what do all these different sort of documents look like? Well, we're going to show you a couple of them. So this is what an intake report looks like, obviously without the watermarks. Let's see if I can get a pointer to go work for me here. So At the top here is the intake number. That'll be a 4-digit year, a dash, and then a 6-digit sequential number that represents when it was like in what order it was received by the hotline. So, at midnight on January 1st, you'll get, 2023-000001-01. That'll be the first report of the new year. It'll say which county the case came from. Can everyone see my laser pointer that I've got? Hopefully.
Yeah, I can see it. So I think
Okay.
everyone else can as well.
Thank you. Okay. It will indicate whether there's been prior investigations or not. It'll have address information. If you request a record and you see that the ID number has been blacked out, that's usually because that's a social security number that's on there. Just pro tip. And then usually on page 2 or 3, there will be what was reported to DCF. It will not be verbatim 99 times out of 100. But it'll be a summary of the allegations describing what was reported to us. So let's just say, for example, that you guys are working with a client that made a report to DCF, but it was not accepted by the hotline because it did not rise to the level of reasonable cause to suspect as determined by the hotline. There will still be this intake report generated. And you are obviously welcome to request that, subject to the statutes I'll discuss later in the presentation. Ultimately, down here near the bottom, it'll say either screen in or screen out. If it's screened out, sometimes they will say why. So it could just be, it could be that, let's just say there was already a DCF investigation and somebody's, it's already been closed and handled, but somebody has called in a new report, 2 months later saying the same allegations happened at the same time. The hotline is probably going to screen that out as a duplicate because there's no need to reinvestigate. So that's what a DCF intake report looks like. Obviously, if you're requesting records for your client, or if your client has requested their own records, all these fields will be filled in, possibly with some redactions. So that is an intake report. So now we're getting to the investigative summary. At this point, I am going to ask Alexis to please deploy to everybody the DCF shorthand document I've prepared as an addendum to this presentation, which will hopefully help you all translate some of what our investigators write.
And that was just added to the chat for folks.
Thank you. So again, we've got the case number up there at the top, which would be that 4-digit year dash a 6-digit case number. Also here at the top, you'll have the time and date the investigation started, as well as the time and date that it was formally closed in the system. You'll have the county it was located in. You'll have the investigator's name and, if applicable, their supervisor's name. Next, you'll have the abuse hotline reports. Again, this will be the allegation narrative or the allegation summaries. It is possible for more than one abuse hotline report to be covered by the same investigative summary. So let's just say, for example, on Friday night, mom and dad have a big, domestic violence incident. Law enforcement is called, and both the responding officer and mom both make abuse reports to the hotline. And let's just say auntie does too, and they all do that over the same weekend. So if the police officer calls first, he'll get the, he'll get the 2023-6-digits-01. That'll be the initial report. If mom calls, let's say Saturday afternoon to report the same information, that'll be added to the same investigation. That'll be either a supplemental or an additional report, depending on whether we're adding information or just adding more information. And that'll be, 2023-6-digits-02, and so on and so forth. So just to let you know, and sometimes we get multiple up to 10, 12, 13, 15 reports throughout the life of an investigation. So the allegation narrative summary can get rather expansive. And obviously this is just a template I'm showing you. These white spaces expand as information is added. Moving on to the next section, this will be where the victim child or victim children are listed. So you'll have a last name, first name, child's date of birth, child's age at the time that the report was printed out of our system. Important distinction. So let's say, for the sake of example, that there was a big DCF investigation back in 2020, but you're now requesting the records in 2023. So the child's name and date of birth most likely will not have changed, obviously, but the age will be their age as of when we pull your report in response to your 2023 records requests. So the body of the report down below may say, oh, the child is 10, but but it says that they're age 13 on the report. So that confuses some folks, just fair warning on that one. Obviously the child's gender, their race, if they have any known disabilities, maltreatment. So maltreatment, DCF has 20, 30 odd different maltreatments. So inadequate supervision, just to give some examples. So we've got inadequate supervision, substance abuse, alcohol, substance misuse, illicit drugs, abandonment. They're all listed out in DCF policy, Children and Families Operating Procedure, CFOP, which can be found on our website. But that just kind of categorizes the different maltreatments that we see within our reports. And it may be the case that there are multiple different maltreatment categories that we're investigating. It may be that there's only one. And it's possible that, let's just say, for example, that it's reported that, child A was sexually abused and child B was found running around in the street. If we receive both of those reports, both children will appear as victim children on the report, but child A the maltreatment will be sexual abuse, and child B, the maltreatment will be inadequate supervision. And they're investigated at the same time, but obviously we're trying to develop access to both concerns that have been raised. Findings. DCF has, I usually describe it as 3.5 levels of finding. So at the scary end of the scale, we have verified. A verified finding means that the child protective investigator has, I beg your pardon, I'm blanking on my verbiage here. Basically, the child protective investigator has enough competent substantial evidence to support the alleged maltreatment. Below that, we have not substantiated, which means that there is some credible evidence to support the alleged maltreatment, but not enough to reach a preponderance of the evidence. The third level down is the one you most likely want to see on your client's investigation record, if it's against your client, and that is no indicator, which means that there is little to no credible evidence to substantiate the allegations made. The half level below that, very rarely seen. It's called patently unfounded. Basically, it translates to somebody was just flagrantly lying when they made an abuse hotline report. That is an extremely rare finding for DCF to make, and it usually results in criminal actions and possibly administrative fines being levied for false reporting. Again, very uncommon. If there's a verified finding, incident date, caregiver responsible, those will both be filled in. If the child is deceased as a result of the abuse, abandonment, or neglect, that information will be filled in as well. And these next 3 fields will also be filled in if there was, if necessary. Next section down, other participants. So this is where we're going to talk about, we're going to list the names, dates of birth, and role of the other adults in the home, and any other children in the home who are not alleged victims. So, for example, going back to our, let's just say again that, child A, possible sexual abuse reported, child B, found wandering around the streets, unattended, inadequate supervision concerns. But then we also have child C and child D in the home, and there are no reported concerns as to them. So child A and B will be listed up here in the victims section, but child C and D and all the adults will be listed down here in the other participants section. For those of you looking at your DCFE's handout, you'll notice that DC is the shorthand for victim child, while CH is the shorthand for child in the home, non-victim child. And that distinction is important for who can obtain records, which I will explain shortly. Below that, these are fields that are written primarily by the investigator. This is very much where this DCFE's handout will become useful to a lot of you. So for example, it might say, DC Jane was spoken to at school. BC indicated that MX said A, B, and C, and Step FX said X, Y, and Z. Things of that nature. Or BC indicated that AP, Mr. Smith, did these things to her. And there are also some local variations on that. So, for example, if we're doing an investigation in Seminole County, you might see SCSO for Seminole County Sheriff's Office. That's another common abbreviation. KPD here in Osceola County would be Kissimmee Police Department. Back in my native Palm Beach County, PBSO, Palm Beach County Sheriff's Office, etc. You kind of get the gist. So local knowledge helps sometimes when it comes to acronyms and sort of the shorthand that our investigators use to generate these reports and other documentation within the DCF record system. All right, so moving on. So some of you are probably asking me about safety plans and wondering what the heck is a safety plan. So let's start out with what a safety plan is in very general terms. A safety plan is a tool used by child protective investigators to ensure the safety of a child while the investigation is ongoing. And it's also used sort of as an alternative to removing the child, to sheltering the child through dependency court, removing them from the parent's care. So safety plans most commonly, let's just say, for example, that the children are living in kind of squalorous conditions. And so the investigator determines that it's not safe for the kids to kind of be there. And so we might implement a safety plan that says, okay, kids, little boy, little girl, you're going to go with your auntie who's volunteered to take you in for a couple of weeks while mom and dad get the house cleaned up. And once the house gets cleaned up, then you can go back home with mom and dad. So it's an alternative to removal so that the kids aren't as disrupted. That's an out-of-home safety plan example. There can also be in-home safety plans. So again, most commonly domestic violence situations, if mom and her paramour have had some sort of big brouhaha, and the kids were, aware of it, present for it, all that terrible stuff, then we might implement a safety plan that says, okay, mom, you will not allow your paramour back in the home, and grandma is going to come by 3 or 4 times a week randomly and check and make sure that paramour is not back in the home. While safety plans are voluntary, if safety plans are violated, it can result in removal of the children and the filing of a shelter petition in juvenile court, which launches a dependency case. So safety plans, useful tool, powerful tool. So looking at the example here, this is what a safety plan usually done in the field would look like. So this is normally a carbonless copy form where the investigator will list off the kiddos' names, what the concern is, obviously the worker name, the case number, all that will be here up here at the top. Down below, it'll describe what actions are going to be taken and who is responsible for them and how often they are responsible for them. So to use the out-of-home safety plan example, it might be, Johnny and Jane will go with Aunt Bertha for 2 weeks while mom and dad clean the conditions that are present in the home, make it safe. The child protective investigator will monitor that, etc. And then there will be signatures down here at the bottom of the form, where normally the parent or caregiver, if it's out of home safety plan or not, safety monitor will sign, the investigator will sign, etc. So that's what a in the field safety plan looks like. Now, this is what a safety plan looks like. All these forms will be typed in rather than handwritten most of the time. Again, same basic information, just looking a little prettier. You've got the case name and case number all floating around up here. Which children this applies to, what the concerns are, and then what's going to happen, what's expected, and then why the safety plan ended. Either it reached the end of its life, which is usually 14 days, but can be extended in increments of 7 days beyond. It could be, so let's just say, for example, that dirty home scenario, mom and dad only need a week instead of 2 weeks to get the house shipshape. Well, the safety plan will be ended at that point because mom and dad got the house shipshape. There's no more need for the safety plan. The kids are now safe. They're good to go. And sometimes there are signatures on these computerized safety plans, sometimes not. Kind of depends on the investigator, the investigation, sort of what's going on there. I'll go ahead and stop for questions now. Does anybody have any questions about what I've discussed and presented so far?
So I don't see any questions in the chat. I'll take a second to ask some questions that came to my mind. I think on the previous slide, you talked about redactions. You mentioned social security card numbers or social security numbers would be redacted.
Yes.
When an advocate is requesting, this intake form or any other records, will other things be redacted, or can we ask for certain types of redactions to be removed? Obviously, Social Security, gets redacted, but is there anything else that tends to just automatically be redacted that we can maybe ask about unredacting when we get those documents?
So the two things that are automatically redacted always that we have to redact: Social Security numbers, which is required by Chapter 119 of Florida statutes, and then abuse hotline reporter information, which is confidential pursuant to 39.202 subsection 5 of Florida statutes, which is a statute we'll look at a little bit later in the presentation. So let's say, for example, that the hotline made a boo-boo, and they're human, it happens. And the allegation narrative says something like, my baby daddy beat me up and my kids were present at the time. Now, obviously, by the use of my and me, that report is coming from the victim or survivor of domestic violence. We don't want anybody, not the attorneys, not the judge, not the abuser. We don't want anybody to know that mom was the abuse hotline reporter unless she explicitly waives that confidentiality in writing. So if an attorney just routinely requests, their clients or the DCF child protection records of their client or their client's children, if the hotline makes a mistake like that, we're usually going to redact, the me, the my, basically any sort of information that would lead a reasonable person to be able to identify the specific reporter. Now, by contrast, let's say that we get a report that, oh, little Johnny can't sit down today because his mother and father spanked him so hard. And it also says that little Johnny is doing okay in school. Obviously, that kind of report is coming from somebody at the school, because again, everybody in the state of Florida is required to report known or suspected abuse, abandonment, or neglect. And that includes specifically teachers, doctors, nurses, all those caring professions that we know and love. But the fact that it's not going to be obvious who specifically from the school was reporting it. So that kind of information we're going to go ahead and leave alone, because the fact that little Johnny's doing okay in school, mom and dad and their attorneys are allowed to know that. That's governed by FERPA. So long as the report does not specifically identify or lead to a reasonable person to know the identity of a hotline reporter, or not, that's kind of where we draw the line when it comes to redaction on things that we always have to redact no matter what.
Got it. Sorry.
Hopefully that, those are the two things off the top of my head that we definitely always 100% of the time have to redact.
Yeah, so I'm thinking for our advocates here, what they can do is if they receive a redacted report and things that are not specifically in the statute as required to be redacted, if other things are redacted, they'd be able to maybe ask for unredaction of those non-required things, those things that are not required to be redacted.
Well, and ultimately, as I'll get to later in the presentation, if for some reason the attorney or the parent objects to a redaction that DCF has made, they're always welcome to ask the judge for an in-camera review of the records, and the judge then determines what the parties get, what they don't get, what needs to be redacted, what doesn't get redacted.
Got it. Great. And the only other question I was thinking of is, I know you mentioned earlier on the intake report, it'll notify that whether there's been like previous investigations.
Right.
And for my clarification, is that like based on a number that's on there, or will it say there are previous investigations, or is there like a tip for that you can see, okay, there is more here that I need to look for?
So I believe the checkbox is actually previous involvement. So even if there was just a screened out report in the past, that box is going to be checked. So let's say, for example, that your client has some childhood DCF history, but you as an attorney only need the information regarding mom as an adult, or your client as an adult, and your client's children. So while there might be prior involvement with your client as a child, and that box will be checked as yes, and you as an attorney could request those records where your client was a alleged victim child, which we're going to get into here in a couple minutes. That's kind of, so that box may be checked yes, but older history may not be relevant. So let's also say, for example, as we'll get into in a few minutes, so let's say dad is requesting records regarding his children, and the report involves mom's house or mom's household. If there are no other prior investigations involving dad's kids, but there have been other things saying, let's say, involving mom as a child or mom's other children, and there have been, if there's been previous involvement that dad is not entitled to, we will normally redact that prior involvement box as to dad's request, because dad's not entitled to know anything other than those records involving himself and his children. So that's sometimes the redactions get a little bit creative when we have to, but that's how it's supposed to work.
Awesome. Well, thank you so much. I know we did get another question that came in, but I'm going to save it to the end because it's open for a little more of a discussion. So we'll go forward and I'll pull that question out towards the end.
Okay. So as I kind of alluded to, let's talk about who can access child protective investigations. The controlling law here, as I mentioned, you might have heard this one, section 39.202 of Florida statutes. And I think this is the point where I'm going to ask Alexis to push out a link to that, if we could, please.
I'll drop that into the chat in just a moment.
Thank you, ma'am. So once you look at 39.202, you'll see that section 1, we start out from a presumption of confidentiality. So while DCF records are public records in the sense that they're created by a government agency, no, Joe Schmo off the street, generally speaking, cannot walk in and request and obtain them. Only those certain people specified in subsection 2 of the statute of 39.202 can access child protective investigation records. So looking now to 39.202 subsection 2, I just want to make sure that, thank you, Alexis. So let's look at some common examples of persons who are entitled to access. If I can get my PowerPoint to work with me here. So legal parents and their attorneys. So legal parent has a specific definition in 39.01 Florida statutes. We're talking about either birth or adoptive mothers. So, mothers who have not had their parental rights terminated. And we're talking about legal fathers. So married at the time of birth conception or judgment of paternity, or now listed on the birth certificate, and attorneys for both of those folks. Court-ordered legal custodians and their attorneys. So a power of attorney generally not going to be sufficient for you to access child protective records. Legal custody is defined, excuse me. So legal custody is defined as a court-ordered situation where a person or entity is given custody of a child. Also, the alleged victim child and their attorneys are entitled to access those records where the alleged victim child is listed as such. So let's just say in the criminal law example that your client is known to have a significant history with DCF as a child, and you want to try and mitigate any sort of, whether it be death penalty or some other kind of criminal consequence, you're assuming we have it, you're more than welcome to request and obtain the DCF child protective investigation records where your client was the alleged victim child. Alleged perpetrators of abuse or neglect and their attorneys. However, that is subject to restriction and redaction under Marcy's law and other applicable laws. So, for example, let's say, you're representing a paramour where dad has filed a domestic violence injunction against the paramour. The paramour and their attorney will be entitled to those DCF child protective investigation records where the paramour is the alleged perpetrator of abuse or neglect. But because the paramour is not the parent of the alleged victim child or victim children, there are going to be significant redactions made such that the alleged perpetrator and their attorney is only entitled to know what the allegations are against them, what evidence DCF sort of generated in relation to those allegations, and what DCF's findings were. That's it. So, kids' names usually get redacted down to the initials, no dates of birth, most likely no ages. You're not going to be able to know where the child goes to school. You're not going to know who the child's, auntie and mother, and whoever else are. That information will be redacted, maybe not the relationship, but definitely the names. Again, we take child protection pretty seriously around here. The guardians ad litem for the alleged victim child or victim children entitled to records. Other state child protective agencies. So, for example, I get requests all the time from Georgia DFACS, New York City Agency for Children's Services, ACS, Ohio Department of Job and Family Services, DJFS. The list goes on. There are, 50 odd other child protective agencies floating around in the United States, and a lot more at the county level in some other states. So long as they do work that is substantively similar to DCF's role under Florida law, we're empowered to go ahead and give them records that they need to do their jobs. We also provide records on a regular basis to law enforcement and the state attorney's office. Important to note, law enforcement and the state attorney's office are both entitled to access abuse hotline reporter information. So, to give you an example, I got called by the state attorney's office to testify in a failure to report case a couple weeks ago, where I just had to basically testify that no, this defendant never reported the known or suspected abuse or neglect of this child to DCF. That's a criminal offense. This is also important for law enforcement and state attorney's office if they're trying to prosecute somebody for false reporting to the hotline. Not common, but it happens. So that's just sort of common examples of folks who have access to our child protective records. So let's do some examples. So the unmarried biological father who does not appear on the child's birth certificate and does not yet have a court order establishing paternity and is not the alleged perpetrator. Is he entitled to access records regarding what he thinks is his child? The answer here is no. He does not meet the definition of a parent nor legal father, both of which are specified in 39.01 of Florida statutes. So if you're not the legal father, legally established father, I don't care that you have a DNA test unless you're either on the birth certificate, got a court order, or Department of Revenue's established child support is to you. I can't give you records unless you're the alleged perpetrator, and even then it's going to be heavily redacted. So how about the family court guardians ad litem for the children, M. Manifest and Bess Entrust? The collective groans you hear come from my esteemed colleagues at the statewide guardian ad litem program. You're welcome. Yep, guardians ad litem, absolutely entitled to access regarding the children whose best interests they represent. That's 39.202, subsection 2K of Florida statutes. All right, now for the audience interaction portion of presentation. How about a social investigator appointed under 61.20 of Florida statutes? Is that social investigator, that family law social investigator, going to be entitled to the DCF Child Protective Investigation records, you think? Alexis, if you can.
All right, let's launch the poll. This is my time to shine. Give me a second. All right, everyone should see that poll question up in front of you. Please feel free to answer. And Logan, tell me when you want to call it, or I can let you know. We have 52 people on today, and I can let you know when we're close to that number of participants.
Yep. And looks like we're getting quite a few responses.
Oh, good. Right. You can see it on your end. Okay.
Yep. We'll get a few more minutes here. We got 23 folks so far. Give it about another 15 seconds. All right. Almost there. And I will go ahead. All right. We're going to go ahead and close the poll, which I will do now. And let's share the results with everybody. So most of you, a gentle majority of you, think that a social investigator is entitled to child protective records under 39.202 Florida statutes. Let's see if I can
let me know when you'd like them to come down.
All right. So unfortunately, the answer to that question is no. Those of you who voted no, you are correct. Social investigators are not listed in 39.201 subsection 2 of Florida statutes. And more to the point, it may also actually be a criminal offense to provide child protective records to a person not entitled to access. That is a criminal offense provided for in 39.205 subsection 6 of Florida statutes. So I would suggest to you that DCF records generally not going to be discoverable. Now, this being said, there is a federal appellate case out there, which is Peck versus McCann. That's 43 Federal 4th, 1116, 10th Circuit, 2022. In that case, the federal appellate court held as unconstitutional a law that was substantively similar to Florida's. Hopefully nobody ever needs that case. Nobody ever gets into trouble for sharing child protective records when they shouldn't. But just a full information, duty of candor towards the audience here. All right, access hypotheticals, part 2. How about the criminal law attorney of the parent or victim child? So I mentioned before, attorneys generally entitled to the same access as their client. So yes, the criminal law attorney would be entitled to the DCF child protective records of the parent or the alleged victim child or victim children that they're representing. And that is regardless of whether the child is now an adult. So again, using that death penalty example, or I get a lot of requests from the Circuit 9 Public Defender's Office. They're wanting to know kind of what their client's background and history is. So let's ask, how about a family friend who has permanent guardianship, which is established under 39.6221 Florida statutes? This would be after a dependency case. Basically a situation where mom and dad are unable to resume custody of the child, but termination of parental rights is not in the child's best interest. The best solution is to place them long-term with a family friend or a relative who has permanent guardianship. So the answer here being yes, but only so long as that permanent guardianship is not dissolved and or the child has not reached age 18, at which point the juvenile court's jurisdiction terminates as to the child, and as does the permanent guardianship. That's the end when the child turns 18. Now, let's just say that allegations were made against the permanent guardian, abusing or neglecting the child while they were permanent guardian. The permanent guardian would still be entitled to those records because they are the alleged perpetrator, but subject to certain redactions. All right, this is a popular one. This happens a lot. Let's talk about, does a relative who has physical custody and a power of attorney from a parent have access to that child's child protective investigation records? And Alexis, if you will push out the next poll, please. And we'll give you guys about 30 seconds to make your choice here. Looks like a lot of you are making the right choice. Great. A few more seconds here. All right, Alexis, if you will go ahead and push the button and share the results. So it looks like almost all of you got the correct answer, which is no. A person who does not have court-ordered legal custody of a child does not have access to a child's child protective investigation records. Good job, everybody. We're getting the gist. All right. Is the Zoom window still covering up my PowerPoint slide, or?
Nope, I can see your PowerPoint slide.
Okay, very good. Oops, and I forgot to animate this slide. All right. So the local TV news reporter, Phil Matt 11, left her here. Is he entitled to a child protective investigation that involves a verified finding for the maltreatment of death? So I know that sounds like it's a lot of English words that sound kind of weird strung together. So I mentioned before, DCF categorizes the maltreatments of abuse, abandonment, or neglect into different sort of subcategories. One of those, we actually have the maltreatment of death. If there is a verified finding for the maltreatment of death, everybody becomes entitled to some version of those records. Now, obviously, if a TV news reporter, that report that he gets pursuant to a records request is going to be significantly redacted to remove a lot of information. But the goal here from the legislature, I think, is that we want to prevent, basically, we want to be able to share with everybody why this death happened and think about how to prevent it in the future. The child's Florida licensed pediatrician would definitely be entitled to their patient's child protective investigation records, as would the mental health professional treating a then child, now adult. So let's say, for example, if your client had a very a lot of abuse and neglect happening during their childhood, and they're working with a mental health professional, that mental health professional could go ahead and make a request and access their client's child protective investigation records for those circumstances where the client was an alleged victim of abuse or neglect. I was supposed to do another poll question here, but I forgot to animate this, so sorry, you got the answer already. So if attorney Lauren Order representing the parent's abusive paramour, who is the alleged perpetrator of abuse. As I mentioned, yes, that paramour would be entitled to a version of the records. However, it is going to be subject to redaction. So we've got Marcy's Law here, which is Article 1, Section 16 of Florida Constitution. That law was recently interpreted by the First District Court of Appeal in Florida Police Benevolent Association Incorporated versus City of Tallahassee. Citation there 314 Southern 3rd 796, and that was first DCA 2021. In that case, we had a bunch of police officers who were involved in officer-involved shootings. Obviously, there's a lot of interest in that kind of information from the media and others. However, the officers asserted that, because they were being assaulted or battered by these individuals who were shot in the line of, that they had to shoot in the line of duty, the officers were in fact victims of crime, even though there was no arrest, no trial. The First District held that yes, that's correct. The officers are entitled to protection under Marcy's Law. That decision was appealed up to the Florida Supreme Court. We are currently waiting on an opinion to be handed down by the justices in Tallahassee. So watch this space. There may be some changes coming in the Marcy's Law realm. And obviously once DCF gets that information, we will digest it and apply it where appropriate. All right, I see that I've already run very close to my hour. I'll pause here. Are there any questions, comments, concerns I can answer?
A question that came to the chat was someone that said, I'm not too familiar with this area of law, but I thought of a question. Maybe this would be under confidentiality. Sure. If the case was reported at home, would the school that the child attends be notified about possible abuse?
Generally speaking, no. Now, this being said, part of the child protective investigation process is that our investigators will try to speak with as many people who have knowledge as possible. So it is possible that the investigator will reach out to the child's teacher, paraprofessional, other school staff, guidance counselors, in an attempt to learn more information or learn unbiased information about what the allegations, about the substance of the allegations. Because if the child is telling the same story consistently, it's more likely that something terrible happened or not, depending on how consistent, what the consistent story is. So that is, as a matter of course, schools are not automatically notified, but we might involve them in an investigation if we need more information from school staff. Hopefully that answers the question.
I think that it does. There were no other questions that came through. There's more to the presentation, right? And then we'll have
just a little bit.
Just a little bit. So, okay.
So
perfect.
if you guys have more questions, feel free to put them in the chat. You got me as long as you need me.
Thank you, Logan.
All right. Yeah, I forgot to animate a lot of this. I'm very sorry. So let's say your client is not entitled to DCF investigation records, but you believe that the said records are both relevant and necessary. Those are the two prongs of an in-camera review for release of records: relevant and necessary to the case at bar. So these, and as I mentioned before, if you also disagree with DCF's, what our redactions are, this is also the procedure you would use. In-camera review of child protective investigation records, that is governed by 39.202, subsection 2F of Florida statutes. You can also take a look at the decision, recent decision in statewide guardian ad litem versus Alberto, citation 351, Southern 3rd, 625. That's Florida 3rd District Court of Appeal, 2022. For those of you in the criminal law realm, hello. There's actually a U.S. Supreme Court case for you, which is Pennsylvania v. Ritchie. That's 480 U.S. 39, and specifically at pages 59 through 61. And that was decided by the Supreme Court of the United States in 1987. The Ritchie decision creates an exception to discovery disclosure under Brady versus Maryland, basically such that DCF record or child protective investigation records are considered confidential, not subject to Brady. And that critique decision also supports the in-camera review procedures found in Florida law. So the normal process here is that the party seeking access will file a motion for in-camera review, describing with specificity what records you need from us. So, for example, you might file a motion saying, I'm seeking all records involving the mother, not just those involving my client's children. The court normally will grant that order, directing DCF to produce the records for in-camera review. Practice tip, just help us out here. Please, please, please have the judges include whether they want the records on paper, through email, or delivered like on a USB drive or through some other means. Some of that's going to be driven by like how many records we have. If we have, like 2 or 3 PDFs, not a big deal to email it usually. If we have a crap ton of records, we're probably going to need to put that either on paper or on a CD or a USB drive or something and have it delivered. Once we produce the records, the judge reviews those records in camera, in private. And then it's up to the court to determine that the records or portions thereof are both relevant and necessary for resolution of an issue before it. So, case in point, had a case, I think last year before, there had been some sort of alleged sexual abuse incident that happened at a school. The school asked DCF for the child protective investigation records, but since no school staff was an alleged perpetrator, it was a student-on-student type incident, we couldn't legally give those records to the charter school. So they had to follow this procedure, file a motion. We had to provide the records to the judge. The judge then went ahead and released those records, determined that they were both relevant and necessary to resolving the civil lawsuit filed by the parent against the school. But obviously the judge imposed a part of the judge's order upon release was that the parties not redisclose the DCF records, would destroy them at the end of the litigation, etc. So that is the procedure for getting access to child protective records when you are not otherwise entitled to access to them. All right, long hypo. I promise this one's fun. So let's set the family up for you. We've got the mom, that's Hera, all right? And you might recognize some of these folks from different Disney and Marvel, because in 2000, Hera married Xavier, right? Okay, so we got mom and Xavier. They gave birth to a child in 2002 named Legion. Cool, awesome. So Hera and Xavier, legal parents of Legion, right? Now, sometime along the way, Xavier, I guess, had to go off something about an X-Man program. I don't know. But Hera was not exactly faithful to her marriage. She got together with a guy named Quill. She got together with a guy named Yondu, and they had a child together named Quill. You'll see there on the right-hand side of your screen a picture of Yondu and Quill, very Quill's younger years. But then in 2011, Hera's like, no, Xavier's coming home. I can't let him know that, Quill was born. Yondu, take him. Finally, in 2012, Hera's like, no, Xavier, I can't stay with you. They get a divorce. Now, in 2014, Hera finds the love of her life and marries Zeus. Subsequently, Zeus and Hera gives birth to Athena and Isis, and of course, most recently, little baby Hercules, right? So we now have 2 different husbands and 3 different baby daddies, pardon my French. Now, obviously, this being a family and sibling group containing a lot of DCF investigations, a lot of superheroes, a lot of Greek gods and goddesses, many DCF investigations ensue because they all live in Florida, right? So now that you got that in mind, remember also that Florida follows the marital presumption when it comes to paternity. So Xavier, technically the legal father of Yondu. Hera that just had to happen because because Hera was still married to Xavier at the time of Yondu's birth and conception. So Yondu files an action against Hera and Xavier for disestablishment of Xavier as Quill's father and for majority time sharing. In Yondu's words, "I may have been his legal father, but I wasn't his daddy." God, I wish this was live. So Yondu's lawyer, Matt Murdoch, a fellow visually impaired attorney, he subpoenas all the DCF child protective investigation records regarding Hera, Xavier, and both Legion and Quill. So what records are Yondu and Mr. Murdoch going to be entitled to obtain from DCF? So Yondu, and by extension, Mr. Murdoch, will be entitled to those records only where Yondu is the alleged perpetrator. So obviously, Yondu believes that, little boys are good for thieving. So Yondu will be able to get those records where he's the alleged perpetrator. But because he's not a parent nor a legal custodian of Quill, under 39.01 Florida statutes, he's not going to be able to get any other records regarding Hera, Xavier, or even of Quill, to be quite honest with you. And they will have to follow that procedure I laid out on a couple slides ago for in-camera review in order to obtain the records sought. All right, now, we have another circumstance here. So Xavier files a parenting plan modification for Legion that was established during their divorce against Hera. Apparently, Legion told Xavier about a situation where Dionysus got into some wine. DCF investigation ensued, etc. Life happens. So is Xavier going to be entitled to those DCF investigation records where Dionysus is the alleged victim child? The answer is most likely no, unless Legion was one of the alleged victim children. And even then, we still have to redact out the other kids' names that Xavier is not the legal parent of. All right. So now that we've gone through all that, let's do a very, very quick demo on how to request child protective investigation records. So Alexis, if you will please push out the link to our records center, which is that fldcfs.mycusthelp.com and all the stuff behind it.
Yes.
Thank you. And this is where you will end up. It is also possible to get here through the DCF main website. I just don't, I'm already over time, I know. So in order to request records, you'll submit on the big button in the middle. It says submit a records request. If you do not have an account already, you'll need to go down here to this gray button that says create account. At which point you'll fill out your email address. Obviously my computer thinks it's smarter than me because it's filling out all my information. So your email address, you'll have to create a password for yourself, first name, last name, phone number, all that good stuff. And you'll click on submit and your account will be created for you. Now, since I've already created an account, I'll just log in as myself. So once you either create an account or you log into your existing account, you'll be brought to this submit a request screen. At that point, you'll describe the records requested. So it might be, all records regarding clients. John Doe, 7.6, something like that. Helps if I learn how to type. Now, they literally just yesterday added these two boxes that are required. So if you know that you're requesting records on behalf of your client because your client is the parent of some kiddos, you'll click that. If your client is not a parent or caregiver, you'll click on alleged perpetrator. If none of these selections apply to you, click other. And this is a work in progress. These are subject to change. Request type. So you're looking for child welfare records. You're requesting on behalf of a parent or caregiver or whatever. You can request HR records. You can request other kinds of DCF records would be requested here too. At this point, you'd probably want to put in your client's name in the next box that says person's full name. So John Doe, his date of birth, 7/26/1990. And because I know that there are a lot of John Does in the state of Florida, possibly some with the same birthday, I'll put in the last 4 of the social just to make sure that we're getting the right John Doe born on July 26th of 1990. Address, if you don't know the address, you don't have to put it, you need something in the box. So you can put unknown if you want. County is not a mandatory field, but it helps us sort which records custodian it goes to. And then to the request, attorneys, you will need to attach some sort of proof of attorney-client relationship. So this can be notice of appearance, order of appointment. If you have a signed retainer agreement, that suffices. If you want to redact the financial details, we don't need to know. We just need some sort of documentation that shows attorney-client relationship, and we're not that picky about what flavor that takes.
And on that note, Logan, to interrupt you quickly, a question exactly on point came in. I want to bring it up is, as the parent's attorney, do we select parent or other?
Like I said, these checkboxes, these selections were just literally added, honestly, yesterday at noon. So you could suggest, honestly, between you and me and everybody watching on YouTube, I don't know that it matters that much. I would go ahead and select parent caregiver because you're acting on their behalf.
That's what I was thinking.
But they may add additional options to this in the future. If you don't feel comfortable selecting parent caregiver, click other. That's fine.
And then submit your proof of attorneyship. Yeah.
Yep, and that gets attached down here. Select file. If a parent is doing this themselves, or an adult, somebody else is doing this themselves, this is where the individual would attach a picture or scan of their photo ID. So back in the bad old days, before we had the system, people would have to come into the office in person and show their ID and make a request in person. Alternatively, it is possible for somebody to submit a notarized letter because the notary checks your ID. All this is to say that we need to, if you're an attorney, proof that you represent your client and who your client is, obviously. If you're an individual or a non-attorney, somebody working outside the government, you're going to need to attach your photo ID to the request in order for us to process it. Once you submit the request, you're going to get a reference number that'll start with letter P. So it'll be like P12345 dash, if you submit it today, the 6-digit date code. So today would be 072623. So that's what would happen if I were to, push submit on this, which I'm not going to. So that's the DCF Public Records Center in a nutshell. Now let's just say, so you'll get a confirmation of your request. You'll get a confirmation when it's assigned to the regional counsel's office in the specific area. Eventually, you'll get a further email from the Record Center basically saying, hey, your records are ready. At that point, you'll come back here. Let's go back to home. You go to My Request Center. You'll click on View My Requests. And usually here you'll be prompted to log in, but since I'm already logged in, at that point you will see your requests and you can view files, view the request, and do all the other things. The system is run by GovQA, so if you've requested records from other agencies in Florida that use GovQA, I know several sheriff's offices and other state agencies use GovQA. Same system, different agency. So hopefully you all familiar with it. If you're not, hopefully this has been a nice explainer for you. All right. Let's talk for a quick second about the Child Protection Team, CPT, in DCFs. CPT, not part of DCF, commonly confused. I get it. CPT is actually part of the Florida Department of Health. They were established by Section 39.303 of Florida statutes. CPT staff performs forensic interviews and medical evaluations of children who are suspected victims of abuse and/or neglect. So if your clients, if the DCF records indicate, or your client indicates that, hey, my child was taken for a forensic interview, that is most likely going to be CPT doing that, not DCF. Now, DCF might have referred them to CPT, but CPT is the one that holds the records of that evaluation, not DCF. Moreover, CPT records are confidential pursuant to section 39.202 subsection 6 of Florida statutes. Not even parents can have access to CPT records. As a general rule of thumb, CPT records require a court order in order to access. Good news for everybody. There is a statewide directory of CPT contacts, which I will ask Alexis to put in the chat now, if she hasn't already, please.
It's in there.
Thank you, ma'am. So if you have questions about child protection team records, I would urge you to please contact the child protection team directly. One of the quirks about CPT records is that, so the child's doctor can access them, but not the child's parents. Law enforcement and state attorney's office and DCF also have access to CPT records. If a child is being forensically interviewed by CPT, a trained staff member will be interviewing them, and it will be audio and video recorded. CPT also performs like physical exams of children who are known or suspected victims of physical abuse of any kind, sexual abuse, any sort of medical evaluation, frequently done by child protection team. But again, their records confidential, held by CPT. Please don't ask DCF for your child's or your client's CPT records. They're not ours to give. All right, last topic, dependency court records. Those are controlled by the clerk of courts, not by DCF. Specifically, the controlling law here is section 39.0132 of Florida statutes, and especially subsections 3 and 4 of that statute. As that statute makes clear, dependency court records are not subject to Chapter 119 Government and Sunshine Law, and they are not DCF records to give out as a general rule. This is supported by the case N. Ray JV, citation 101, Southern 3rd, 407. That's Florida's 2nd District Court of Appeal, 2012. You'll also might want to reference the case of State v. Wooten. That's citation 260, Southern 3rd, 1060, and specifically at 1069, Florida 4th District Court of Appeal, 2018. Access to judicial branch records is governed by the rules and decisions of the Florida Supreme Court, not Chapter 119 of Florida statutes. The clerk is only required to keep DCF, or is only required to keep dependency court records for 7 years or until the youngest child turns 18. Now, this being said, most clerks of court keep those records for a lot longer, especially those records created 2008 and after, when everything went digital. So even if you think that the clerk might have destroyed your client's records, go ahead and ask. They might still have them. Folks who can access dependency court records. So the child who is the subject of the dependency case and their attorney. So again, using the criminal law example, if you know your child had a rough childhood, your client had a rough childhood, and you know that they spent some time in foster care, go ahead and ask the clerk for their dependency records. They might still have them. Parents and their attorneys. It does not, but this does not include parents whose parental rights have been terminated because they are what? No longer parents. Law enforcement also has access, and of course DCF, the guardian ad litem. A note about and their attorneys. It doesn't matter which attorney of the parent or child is requesting those records. In the case of CG versus RC, that's citation 280, Southern 3rd, 1098 at pages 1106 through 1107. Florida First District Court of Appeal 2019. In that matter, that was a family court case that was up on appeal. In that specific case, the first DCA held that it didn't matter which parent of mom requested the dependency court records, so long as mom was entitled to access, her attorney was entitled to access. Didn't matter which attorney of mom. So it could have been mom's family attorney, mom's dependency attorney, mom's criminal attorney. So if you run into trouble with that with any of the clerks of courts, feel free to call me. I will help you sort that out. That is the end of the information I was planning to cover. Do we have any other questions, comments, concerns, things I can answer? Again, I cannot answer case-specific questions nor hypotheticals.
Okay, and I think the last question that we have that came in, it came in earlier. I'm not sure if it's something that you can answer, but it would be interesting to see your perspective as someone that, is with DCF. Someone did ask, does attorney-client privilege overrule mandated reporting? And I feel, I see your smile, and I'm thinking the same thing, that it's always, your ethical issues, your attorney obligations, there's always a tension. So if you can't answer the question, no worries, but I'll pose it to you to see what you have to say. And before you answer, I just want to let people know, CLE code is in the chat, 230-6814, N as in Nancy. Jot it down, put it in, it's in there.
So there are statutes that address this. So for example, most other kinds of privilege are abrogated when it comes to abuse hotline reporting. So for example, if the child or the parent tells their doctor or mental health professional something, the doctor or mental health professional most likely is going to be obligated to report it. Same thing goes for, well, those are the two examples that come off the top of my head that I feel comfortable giving information about. Honestly, my recommendation, call the ethics hotline. Call the Florida Bar's ethics hotline, ask them that question. That way you cover your butt as an attorney. And that's kind of what we pay them for.
Yep.
Alternatively, you might think about telling your client that they need to report this information, because again, 39.201 Florida statutes, everybody in the state of Florida is a mandatory reporter. And DCF cannot release abuse hotline reporter information outside of certain very specific circumstances. So law enforcement, state attorney, child protection team have access to reporter information. So DCF, unless something dramatic happens, almost definitely not going to give up the fact that your client is the reporter. So if you get that question about, if your client is telling you a story that sounds like abuse or neglect or abandonment of a child, I definitely urge you to report it. Judges and clerks of court too also are required to make reports to the hotline where necessary. There is a JEAC opinion about all that, and you can look that up on their website. Usually if the judge is making a hotline report, they have to recuse themselves, but that's a story for a different presentation.
All right, and give me 1 second, Logan.
Of course.
All right, and 2 more questions that did come in are, one, is there specific training in handling undocumented immigrant children and families?
Specific training with regards to records, I don't believe so. Specific training with regards to our child protective investigators out in the field. We do have some policies and procedures regarding immigrants. That is not a question I know the answer to, unfortunately.
Okay. Another question that came in is, what is the expected time frame for records requests?
Okay. So DCF records custodians are generally subdivided by circuits or groups of circuits. So for example, up until a few months ago, I was the one and only DCF records custodian for circuits 9 and 18. So that's Orange, Osceola, Seminole, Brevard counties. the records custodian for DCF that sits in Miami. She serves both Miami-Dade and Monroe counties. Broward County's records custodian in Fort Lauderdale just serves Broward. Palm Beaches just serves Palm Beach County, but the one in Circuit 19 serves Okeechobee, St. Lucie, Indian River, and Martin. All this is to say that the turnaround time very much depends on what county or counties the requested records reside in or sit in, where the investigations occurred. As a general rule of thumb, we process records requests on a first come, first served basis, just to be as fair to everybody as possible. It is generally a first come, first served basis within your judicial circuit or region, depending on how big your circuit or region is. We try to turn them around obviously as quick as we can. If you have some sort of looming court hearing coming up for which you need the DCF records, you can feel free to reach out to our Office of General Counsel up in Tallahassee. Or if you want to touch base with me, I might be able to at least get you pointed in the right direction of who you need to talk to. We don't have an official policy on expediting records requests per se, but most of our folks generally try to move it forward when necessary and when especially for looming court hearings.
Okay, and the last question that came through, and then we're going to have to hop off, we're around in that 1:30, is can an attorney for a great aunt caregiver get DCF records of a niece when DCF left the niece in her care? Are there any financial benefits for a caregiver relative? And that question is in the Q&A if you need to look at it, to
okay,
answer.
So while that is kind of a case-specific hypothetical type of question, a lot of it is going to depend on under what circumstances the great aunt has physical custody of the niece. So if there is a court order under, let's say, I think it's Chapter 751 that governs relative caregivers, or maybe if there is a dependency court permanent guardianship order. So basically the question is there a court order? If the answer is yes, then great aunt / legal custodian is going to be entitled to niece's child protective records where niece is the alleged victim child. If there's not a court order or not yet a court order, even if DCF placed the child with the great aunt, the answer is most likely going to be no. So that does lead to the circumstance where, let's say, for example, in that example, great aunt might need to go ahead and file a petition for relative custody in family court and also a motion for in-camera review of the DCF records and have the judge review the DCF records regarding the niece in camera. I know it's kind of a weird circumstance. That is unfortunately what the law requires. And that would be my suggestion if that is the route you need to go down.
1 second. All right, everyone. Well, thank you so much for attending today's webinar. Logan, thank you so much as well.
Thank you.
Everybody said what a great presentation that has been. They said that in all of the chats and the Q&A. So folks, we're going to sign off for the rest of the day today. The CLE code is in the chat. And Logan, thank you so much for everything. I'll be in touch soon. Thank you all for attending and have a fantastic rest of your day.
Thank you, Alexis.
All right. Bye, Logan.